Good afternoon. My name is Robin Kincaid. I'm from Nevada PEP, and I want to welcome you today to our webinar. Today, we're going to be talking about evaluation and response to intervention. We are very glad to have you join us, and we hope that this next hour will be information that will be helpful and give you additional opportunities to advocate for your child or other children that you know who have disabilities and either need services or need their services expanded in some way. Nevada PEP is celebrating 25 years of excellence, and we are pleased to be able to bring you this webinar. Nevada PEP has been helping Nevada's parents and their families who have children with disabilities, again, for over 25 years. We are all parents of children with disabilities or have some connection to a person with a disability and are here to be able to provide information, encouragement, and also empowerment. We encourage you to ask questions. We do have a question pane, and hopefully we'll be able to see you. I'll be able to post a question. We also have some handouts. We want to make sure that you have an opportunity to download those handouts as well. We're a nonprofit organization, and we're part of a network of parent centers all over the United States. These parent centers provide training and services to families and professionals. All of our services are provided to families at no charge. We encourage you to visit our website on a regular basis, which is the nvpep.org, in order to gain additional information or to learn more about another training. We also have a hand-in-hand Together We Can award program, and we would also encourage you to consider nominating someone that has made a difference in a child's life. And these nominations are accepted, and Nevada PEP provides a pen, a little pen, lapel pen, and a certificate. We are active participants in bullying prevention, so please visit our I Care, We Care site as well. We have a variety of other archived webinars, and we would encourage you to look at some additional topics as well that may work for you. We're going to get started on our topic today, which is evaluation and response to intervention. I'm going to go ahead and switch out that slide so you can take a look at that. Stop showing the screen for just a moment. Okay, you should be able to see our screen now. There we go. So our mission is to increase the opportunities for home, community, and school success for children with disabilities, including those who are at risk or who have serious emotional disturbances, their families, their service providers, through education, encouragement, and empowerment activities. Once again, if you download those handouts, you'll have a copy of the slides that we're going to be going through today, and also some additional materials that will provide additional information about evaluation and response to intervention. This set of training was developed by the PACER Center in Minneapolis PACER provides technical assistance to parent centers, and like Nevada PEP, we've adapted this training to reflect Nevada Administrative Code regulations. We're going to share also with you throughout the presentation some newly released information from the Nevada Department of Education on COVID-19. That may also help clarify a little bit more about the timelines that are still intact for families that are accessing services under IDEA. When we're working with families, we often talk about the differences between acts and statutes, rules and regulations. As your child's advocate, it's important that you're able to participate with as much knowledge as possible, especially during this COVID-19 and the distance learning period. Learning more about the different laws that apply to you and your child can help you advocate more effectively for the services that you feel your child needs. It's also important for parents to understand the distinctions between these three different types of rules or regulations that they might encounter as they're working with school staff. The Individuals with Disability Education Act, also known as IDEA, clarified that the statutes written by the U.S. Department of Education and the actual regulations get released after the statute's passed. These regulations explain how the services are going to be provided to children with disabilities. School districts have policies and guidelines, maybe in areas of attendance or behavior, that all students are expected to know. However, if a district policy or even a state law is in conflict with the federal acts or regulations, they can be challenged and changed. One example that we encounter often is maybe more like a zero tolerance policy that are established in districts across the nation. Those policies might have harsh consequences for behaviors that school districts have specifically addressed in their policies. If the consequence, such as expulsion or long-term suspension, are in conflict with a child's right to free, appropriate public education, then the policy can't be implemented. Parents who have concerns about policies and guidelines that lead to their child being unfairly treated can carefully examine and compare the policies to their state laws and the federal acts and regulations. Now we're going to take a look at, on your screen, the circle, which shows us, first of all, the 14th Amendment to the Constitution. It was primarily intended to establish equal civil rights for former slaves. The 14th Amendment contained three major provisions. The Citizenship Clause granted citizenship to all persons born or naturalized in the U.S. The Due Process Clause declared that states may not deny any person life, liberty, or property without the due process of law. The Equal Protection Clause said that a state may not deny to any person within its jurisdiction the equal protection of the laws. By directly mentioning the role of the states, the 14th Amendment greatly expanded the protection of civil rights to all Americans and is cited in more litigation than any other amendment. So this really applies to persons with disabilities. Again, this is an equal opportunity or equal access that the 14th Amendment protects for all citizens. As we move further into the circle, the American with Disabilities Act, also known as the ADA, was created in 1990 to prohibit discrimination and to ensure people with disabilities have equal opportunities for employment, public accommodations, transportation, and access to all facilities. Section 504 is our next spot in the circle, and it's a civil rights law that prohibits discrimination against individuals with disabilities. Section 504 ensures that a child with a disability has equal access to an education. Child may receive accommodations and modifications. The purpose of Section 504 is to protect individuals with disabilities from discrimination for reasons related to their disability. As we move further into the circle, in the center of the circle, we have IDEA, the Individuals with Disability Education Act. It's a law that makes available free, appropriate public education to eligible children with disabilities throughout the nation and ensures special education and related services to those children. The Nevada revised statutes are all the current codified laws of the state of Nevada. Nevada law consists of the Constitution of Nevada, the state constitution, and are based on state legislation that has been passed and signed by the governor. Over on the right, we see the Nevada Administrative Code. This is the codified administrative regulations of the executive branch that are developed from those Nevada revised statutes. In the center, we see the Family Educational Rights and Privacy Act. It's a federal law that affords parents the right to have access to their children's records, the right to seek the education records amended, and the right to have some control over the disclosure of personally identifiable information from those education records. Now we're going to move in and talk a little bit more about response to intervention. So Nevada has developed standards and regulations that give school districts flexibility in using response to intervention to address struggling learners and to improve the instruction for all students, including general education students. There really are no timelines, and parents can always request an evaluation at any time they suspect that their child may have a disability. Let's talk a little bit about the objectives of the RtI. We know it's a process that refers to how well students respond to research-based instruction. The purpose of the program is to provide a safety net for at-risk readers, some of whom have possible learning disabilities. At one time, students could not get the help that they were failing. The idea of RtI is to catch students when they begin to struggle. RtI supports their success through scientific research-based instruction. And of course, the child is frequently tested to see how well that instruction works. And that's where parents may want to be asking more about that data and asking to sit down and look at the data with school staff to see whether or not there is progress. And is the child catching up is the question that often parents want answered. So here's a tier that demonstrates the response to intervention process. So in tier 1, the students receive high quality curriculum and instruction in the regular education classroom. In tier 2, the school provides interventions to students who need more support than they're receiving from the general curriculum. In tier 3, the students are giving that individualized instruction, once again, to help them catch up so that they have the opportunity to be able to be closer to the grade level that their peers are at. Now we're going to take a look at a video real quick. I'm actually going to stop showing the screen for just a moment while we make sure that that thing is ready to go. Bear with me just a moment. Let's see if we can get that video going so that you can see it.
Here, we'll look at a three-tiered model, often depicted as a triangle, as one example of how a tiered framework.
Okay, now we're going to start that. Let's try to get the audience feedback.
Here, we'll look at a three-tiered model, often depicted as a triangle, as one example of how a tiered framework can be used as a school-wide strategy for instructing all students. All students will participate in Tier 1 instruction. At this level, they'll receive effective differentiated instruction provided by the general classroom teacher as part of an evidence-based core curriculum. The evidence-based instruction offered at this level can be expected to meet the learning needs of 80 to 85% of all students. For students who don't respond adequately to Tier 1 instruction, more intensive interventions come into play. Tier 2 interventions build upon the differentiated instruction provided at Tier 1 by offering students more systematic instruction and interventions strategically designed to help them catch up in areas of difficulty. These interventions are usually delivered to a small group of students within the general classroom, either by the classroom teacher or by another team member supporting the teacher who has also been trained to deliver the interventions. Tier 2 interventions will be offered to the 15% of students for whom Tier 1 instruction was not sufficiently intensive to meet their specific learning needs. But here is a critical point. Students who receive targeted Tier 2 interventions continue to participate in general Tier 1 instruction. Tier 2 interventions do not replace the core curriculum, they supplement it. For example, Dennis has been selected to receive Tier 2 interventions based on the results of recent reading fluency data. He'll continue to participate in the 90 minutes of core reading instruction that is provided to all students in Tier 1 each day. But in addition, he'll spend another 30 minutes per day receiving targeted reading instruction at Tier 2. Under RtI, his opportunities for learning and for catching up to his classmates will have been extended. We've saved the most intensive interventions available for the small percentage of students who still lag significantly behind their peers in making academic gains. Tier 3 interventions supplement the previous tiers by providing the most intensive evidence-based interventions delivered to individual students or in very small groups. Again, the intensity of instruction at this level increases. The size of student groups is reduced and their opportunities for direct instruction extended. Interventions in Tier 3 may be delivered by an intervention specialist or even a special education teacher. But again, these interventions supplement the instruction provided at Tier 1, not replace it. And students do not have to be identified as disabled in order to receive these interventions. Only about 5% of all students will require these intensive Tier 3 interventions. Of these students, only a portion may go on to require special ed services. Here, we'll look at
Okay, we're going to stop sharing the screen for just a moment. Go back to our PowerPoint.
Often depicted as a triangle.
Oops. Okay, let's see if we can have a little conversation about this. I'm going to show the screen, the video we just looked at. So let's kind of think about this video for just a moment. Let's talk about which teacher is primarily responsible for the interventions. Well, I think what we learned out of the video is it's the general ed teacher is really the one who's kind of like driving this. Certainly, collaboration with the special ed teacher is going to be important. The video also talked about some increase in reading instruction time. You know, parents can ask about the amount of time that the class receives for reading instruction and how much more additional time is reserved to extend the reading instruction for the student that is receiving response to intervention. Okay. So a lot of this process starts with that initial concern. So when families are concerned about their child's academic progress, or they're seeing behavioral difficulties on campus or even in distance learning, it's important to start asking questions by talking with the teacher. That's always the place to start is with the teacher. Conversation could include talking about grades, missing assignments, and testing to help understand why the child is not making progress. Some of the things that have been inherently part of the distance learning has been the pace of instruction. And so it might be important to look and see how this child is struggling with the pace and what can we do about that. And is a child getting enough instruction through the distance learning process to understand the content and therefore be able to apply it in working independently. Families want to use this term suspect. I suspect my child has a disability is going to be an important part of the conversation. When parents suspect, we often are looking at the different eligibility categories. Let's take a look at those right now. And the different eligibility categories help us understand the process and how a child could become eligible for special education services. Remember, the eligibility categories don't actually drive the services, the amount of services or what services. They also don't drive placement. Although a child can have a medical diagnosis, they also have to demonstrate a need for special education in order to be determined eligible. Children that might have attention difficulties and have a diagnosis of ADD or ADHD could be listed under health impairment. In Nevada, a student under the age of 6 may be identified as eligible as developmental delay. So the process of obtaining special education services often starts with that initial evaluation request. Of course, being familiar with these 13 eligibility categories can help families write the letter with enough information so the school staff understand the parents' concerns and what they suspect and the areas of disability that they would like the school to look at in order for the child to receive this additional help and support. So if state and local decisions have required schools to limit or not provide in-person instruction, due to health and safety concerns, the school teams are not necessarily relieved of their obligation to provide free, appropriate public education to each child with a disability under IDEA. So just because we might be in a pandemic or under emergency order does not change the school's obligation to respond to an evaluation request from a family asking for the child to be tested and stating their concern and what they suspect in the area of a disability. Also, the fact that we are in a pandemic or our students are receiving distance learning doesn't change the timelines. Nevada PEP recommends that parents put all requests for evaluation in writing to document the date of the initial request. So it's well documented that the family has a concern and that they're asking the school to look further into their concern by providing an opportunity for the child to be evaluated. There just can't be an unreasonable delay between the time the parent requests this evaluation and the time where they can provide that informed written consent. Parents may want to ask the school district staff if there's any forms that need to be completed in order to understand when the assessment will begin. As a reminder, according to the Nevada Administrative Code, if the school district, determines that there's good cause exists to evaluate the student, it must conduct this initial evaluation within 45 school days after the parent provides that written consent. That's why families are going to want to make sure that they have that opportunity to sign a written consent, and really not giving a verbal is not acceptable. Even during an emergency state or pandemic, the family needs to make sure that they are providing consent and understand what they're providing consent for. So they do need the form. They need to be able to look at it and review it and then give that consent. I want to remind you to download those handouts. Also, we have the question pane open, and you're welcome to type in any questions. Make sure that that is open. And we also hope that you'll be able to get those handouts so that you can continue to learn more about evaluation and response to intervention. We've also created some tips that might be helpful when we're talking about evaluation and response to intervention. So none of the timelines for the process to complete the evaluation, reevaluation, or even the IEP meetings have been waived as a result of the pandemic. So explaining your concerns and why you feel an evaluation is needed is important. Often we're putting like a puzzle together of information that helps the school understand why this concern is there. For the family to hear that the child's still making progress is a concern if the child is still significantly below other students in the same grade. If this progress has just been very, very minimal, then the family may have concerns that the child's never going to catch up. As we mentioned before, that the school district has to make these reasonable efforts to get this informed written consent. Now, if the parents do not provide consent and the idea of pursuing an evaluation is something the school has been interested in talking with the family, and the parents say we're not ready, or we don't really think that he's that far behind, then the school district can't be held accountable for having prior knowledge of the student's disability. So the school district could provide electronic or a digital signature process to indicate that the parent consents to the child's evaluation or reevaluation, or the initial provision of special education and related services. The only thing is that it's as long as the public agency or the school district ensures that there's appropriate safeguards in place to protect the integrity of the process. So it has to be an official process. Many times school districts are using a more formalized type system that allows the parent to fill in the signature or fill in sign in some kind of a document, such as Adobe. So they need to have a process in place. It's not reasonable for the district to necessarily have the family like print and sign and scan. They need to come up with a process. So evaluation is not used solely for eligibility. It also helps determine the child's needs. Such as if they needed speech therapy or occupational therapy or physical therapy or any other related services. So we're trying to obtain a picture of where this child is at and get enough information so that we can determine what kinds of goals that the child would be working on with the school staff, or how much time of special education services would be needed for the child to make progress in a certain academic area. So parents should receive current information in the area of present levels that tell them where their child's functioning in all areas. So we're going to be looking at academics, but also like social emotional, behavioral, and then looking at how the child's doing in gross motor skills and then fine motor skills. As a reminder, goals are developed from present levels. If the school creates a goal on, for example, telling time to the nearest half hour, it would be important that the present level indicate that the student could already tell time to maybe the nearest hour. So we're just trying to help the student be able to make progress and age appropriately be able to work on that skill so that they would gain that skill similar to their peers who may already have acquired the skill. So tests also must include those which are tailored to assess specific areas of educational need, not merely those that are designed just to provide a single, like general intelligence quotient or IQ. We're not just looking for IQ. We want to know how the child's doing in a variety of areas, such as math or English language arts, and certainly including written expression. We want to know how that child's doing and compare it to his peers. So evaluations and assessments can't be discriminatory. So if a child doesn't know information about what others might perceive as a real familiar kind of thing because the family in their culture doesn't access information like that, then we can't hold it against the child if they can't be able to talk about a well-known character or information. Children with sensory impairments must be given tests which accurately reflect the aptitude or achievement test or level, or a child who's nonverbal, determining an IQ with a verbal response would be inappropriate. So we have to recognize if the child has a sensory, child has a visual impairment, then we can't give them tests that might have extremely small font so that they couldn't really participate because of their visual impairment, and then try to say that their academic levels are too low. So we have to consider how sensory impairments, the ability to communicate, how does that have the impact on the child's ability to complete assessments? So now we're going to talk a little bit about the purpose of IDEA. So the regulations that were passed in Congress back in 2004, they state the main purpose of IDEA are to ensure that all children with disabilities have available to them free, appropriate public education that emphasizes special education and related services designed to meet their unique needs and prepare them for further education, employment, and independent living. To ensure that the rights of children with disabilities and their parents are protected. to help states, localities, and educational service agencies and federal agencies provide for the education of all children with disabilities, and to assess and ensure the effectiveness of efforts to educate children with disabilities. This often means to parents and to educators that we need to be using best practices and methods and strategies that we know are going to help children make meaningful progress. So all decisions that are made for children with disabilities really do need to be based on data. The Nevada Department of Ed guidance that we received in November 2020 reminds us that decision-making is key with regard to the provision of free, appropriate public education to each student with a disability during these unprecedented times. One of the tenets of IDEA is the concept that parents really must have the opportunity to participate in meetings. So schools must take steps to ensure that parents have that opportunity. And the meetings relating to the child's education, identification, evaluation, placement, or provision of free, appropriate public education. This also includes scheduling the meeting at a mutually agreed upon time and place and notifying the parents early enough so they have the opportunity to attend. So it is important that schools provide parents with a written notice before the meeting that includes the details of the meeting. We also refer to that as a prior written notice because it tells the purpose of the meeting. We do recognize that during this time where schools have been closed, that it has been difficult for schools to provide notice in person. So we certainly understand the guidance that we've received that talks about the prior written notice can be provided through electronic mail. Also, Nevada PEP provides support for families that may need to learn more about how to participate in meetings that now are in a virtual status, where in the past they may have gone to the school and sat down and now they're feeling a little bit, again, more isolated and not sure of how their participation has changed because the meetings are virtual. The school also should give some technical assistance, making sure that families understand what the platform is, what the link is to obtain, to do that. Maybe even talking about the importance of everyone having their camera on, making sure that no one's on mute, some certain kinds of social norms that we've not had to deal with in the past. And so families may need extra support from both the school and centers like Nevada PEP in order to feel like that they are able to participate. The meeting notice also has to include a list of persons that are going to be in attendance in the meeting. So it's important for parents to know who's going to be at the meeting so that they can be sure that, all their questions and concerns can be addressed. Also want to know the role of each person. So they might have a name, they might have teacher, but do they understand, are they the special education teacher? Are they a teacher that teaches the child math in the general ed classroom? All these kinds of questions probably need to be asked and answered prior to the meeting so families are feeling a little more confident about their participation. The notice also must inform the parents of their right to invite people to the meeting. Parents could invite a family member, a friend, a babysitter, a behavioral therapist, or an advocate, or a Nevada PEP representative to come with them to the meeting. There's no obligation for parents to provide notice for anyone that they are planning on inviting to the meeting unless the parent is inviting an attorney. However, the virtual world that we're living in today sometimes requires us to be able to let the school know, because of the way people are added to meetings. They're added to meetings in a way that they're sometimes in a quote, a waiting room. And so giving the school names of people that are going to attend with the family is probably going to be important so that they don't ignore someone that is waiting to be admitted into the meeting. Fortunately, it's part of just the virtual platform that we're living with today. Parents must receive a copy of their parental rights at least one time per year. School must also take steps to ensure the parents understand the proceedings of the meeting. This includes providing an interpreter for parents whose native language is other than English, or for parents who are deaf or hard of hearing. To ensure that an interpreter is present, it is a good idea for parents to remind the school that the accommodation is necessary. We did mention earlier about prior written notice, but there is a requirement that prior written notice be provided in instances when the school proposes or refuses to initiate or change. So when parents are requesting a service and they are told no, regardless if it's done in an IEP meeting or in an email, they still should ask for prior written notice in order to understand the decision that the school has made in response to their request. Some examples could be when the school refuses to initiate an initial evaluation. The family says, I suspect my child has a learning disability, or I suspect my child's attention is interfering with his education or his ability to make progress, and I would like an evaluation. And the school says, no, I think everything is fine. They need to provide prior written notice in order for the family to understand what their response is and communicate why they believe the child does not need special education. Also, maybe when the school proposes to change placement, the educational placement, not the location, but the actual placement. Families would need to understand why the school is proposing that and how they can work together to determine what type of placement would be appropriate for the child. Also, when the school refuses to increase the frequency of related services, if families are feeling as though that the related service needs to be increased, the amount of time that they're working with a provider, families would want to learn a little bit more about how goals might drive the amount of services and what that service provider, like a speech therapist, would do to help the child be able to learn more and support the other goals in the child's IEP. So IEP teams should work together to come to agreements in as many areas as they can as possible. Let's talk about some other interventions that may require parent consent. These are some other things that we want to talk about, whether or not there is a functional behavioral assessment required, if there's a behavior intervention plan, giving consent so that additional data could be collected. Certainly, if families do not suspect that their child is eligible under the 13 categories, but they still feel as though that their child needs accommodations, they could be talking to the school about a Section 504 accommodation plan. Nevada PEP could help with that, getting that process started. Typically, that process is talked to the principal or the 504 coordinator at the school, which sometimes could be the school counselor. Remember, students that do receive accommodations is just another way to help a student that is struggling to be successful in school. If they have the opportunity to work on the pace of the work through those accommodations, especially in the distance learning. So children that are struggling in distance learning, we need to find some ways to help them. And Nevada PEP is here and available. We encourage you to call and talk to one of our PEP representatives if you have a child that is not doing well in school, and particularly in distance learning. And we'll talk about what can we do to help that child, and what are some of the things that are causing the child to shut down or struggle in keeping the pace of assignments that the school is giving the child. I'm going to talk a little bit about independent educational evaluations. After an evaluation is completed by the school district, if the parents disagree with the evaluation, and not necessarily the eligibility, but if they don't believe the evaluation is detailed or comprehensive enough, they could have someone outside the school system evaluate the child. And this is called an independent educational evaluation. Parents would also help select the person or persons who's going to do this additional testing. The credentials of that person in the community must meet a certain criteria. They must have at least the same credentials as the initial evaluator in the school district. And then the outside evaluation that's complete in the community would be complete at no cost to the parent. So the school district must either agree to fund this evaluation in the community at no cost to the parents, or they would file due process on the family to request a hearing to show that the original evaluation was appropriate. Most of the time, not all the time, but most of the time, families that request an independent educational evaluation are able to obtain that, and that the districts generally are agreeing to pay for those. However, there certainly can be exceptions, and so families would want to look at this process. And of course, if they decided that they're concerned about the district filing hearing request on them, they could withdraw their initial request for the independent educational evaluation. Nevada PEP has a sample letter that families could use to request the independent educational evaluation. There are no timelines, so families have pretty much unlimited time to locate a provider and get their child to the provider. And during the pandemic, it has been a bit difficult sometimes for families to get their providers to open up their offices and see children. However, that kind of varies based on what part of the state you're in. So families would just need to call a provider, and Nevada PEP could help provide a list of recommended, or not recommended, but they're actually providers that the district has a list and can share information so that families could call and interview and decide what provider they would like to use in order to gain more information about how their child learns and get more detail. They also may feel as though that the evaluation, if it was done over a platform and not done face-to-face, might be inadequate because they didn't get good response mechanisms from their children because of the nature of how it was administered. So having that evaluation done in the community where it's face-to-face may give us a little more information about how that child learns and the child stops learning and what we need to do in order to support the child as we look at developing an IEP that helps that child be successful in school. Next topic we're going to talk about is reevaluation, which occurs every 3 years. According to the Nevada Administrative Code, parents must be given the evaluation report and, of course, any documentation relating to the determination of the student's continued eligibility. Of course, this information is provided prior to an IEP meeting. The school staff may have conversations with parents about the need for additional information or evaluations and request that even a waiver be signed. So there is a possibility, instead of just automatically doing the 3-year reevaluation, that both the school district or the parents could propose the idea that they have enough information, it's a continued eligibility, not a whole lot has changed, and that they would like to consider doing a waiver. However, we know kids change a lot, and so we certainly have concerns if we see kids that do not get evaluations for example, like 6 years. So parents would really want to think about, how much progress. Maybe the family's done a tremendous amount of tutoring or has worked with staff to do applied behavioral analysis, which is a process to work on behavioral strategies and modification. And maybe the child's made tremendous progress in communication. So the only way to capture that is probably to do a reevaluation. So parents want to think carefully whether or not a reevaluation is something that is going to give us enough information to help the child be able to have an IEP that meets his or her needs. For young adults, a current assessment information is often helpful when assessing adult services. Parents may request a fuller reevaluation, even though the school provides notice that no additional data is needed. Again, Nevada PEP has a sample letter to assist parents to request a reevaluation if they believe that they have decided not to do one. And sometimes the families are considering, because of the pandemic, that they'd like to push it out a little bit further until things go back to a state where children are going to school and there are more face-to-face evaluations. So that could be one reason that they decide to defer it, or if the child is making a transition from 5th grade to 6th grade, or from 9th grade to 10th grade, or 8th grade to 9th grade, and the family wants to wait until they're in a different school setting before they look at doing some additional reevaluations. Every family, every child, the situation could be different and unique, and families will have to think about and talk with even their Nevada PEP representative to ask, some of the ways that we can still make sure kids are making progress, and do we have enough information? And the other thing that the evaluation could tell us, or the reevaluation tells us, is whether or not the child has actually regressed, and do we need to be talking about compensatory services or a way to help that child catch up because of the lack of instruction. When the pandemic first started, we had several months where children may not have been getting much instruction because of the lack of ability to maybe shift to distance learning. And so that has created maybe some gaps in the child's education and understanding. So we want to figure out ways to recoup that. And the guidance is pretty clear from the Nevada Department of Education about how we should take a look at these situations and ask the right questions to figure out where the child's at and be able to work with the school in this collaborative, creative way in order to determine what kinds of services need to be given to help the child get back where they were, or to make progress and continue to gain enough instruction in order for the child to go from grade to grade and learn that curriculum. Okay, I want to thank you for being part of our webinar today. Again, I want to remind you to be able to have the opportunity to go ahead and select any of these handouts that are in the handout pane. Appreciate the opportunity to talk to you today about evaluation and response to intervention. We believe that this is a very important part of the rights that parents have, and want to make sure that you have enough information in order to make the decisions of whether or not a family wants to pursue evaluation for special education or for any related service. Nevada PEP continues to advocate for Nevada students with disabilities. Please take a look at the special education in a pandemic handout that is in the handout section. As school districts and charter schools plan for maybe the reopening of schools, it's important to remember that there is no one-size-fits-all approach for students with disabilities. Schools must provide free, appropriate public education for students with disabilities who are eligible under Individuals with Disability Education Act IDEA. FAPE includes special education and related services designed to meet the student's unique needs and prepare the student for further education, employment, and independent living. Despite the COVID-19 pandemic, when school is in session, students with disabilities remain entitled to receive FAPE. I'll leave you with that note. Encourage you to reach out to Nevada PEP. Please visit our website, nvpep.org. Don't forget our 800 number, 800-216-5188. Thank you again for being part of the Nevada PEP family, for being part of our webinar today. And we hope you have a wonderful day. And please stay healthy, stay well. Thank you.